Welcome to our webinar this morning. If you don't know us yet, HR Collaborative is a community of fractional HR experts who help small to mid-sized organizations make work better by providing HR talent and solutions when and where they need it. We are proud to host Varnum and their experts on HR compliance changes Michigan employers need to know, which includes ESTA, the Improved Workforce Opportunity Wage Act, overtime, and more. And I want to send a special thank you out to the Manufacturing Growth Alliance for partnering with us on this important topic. A little bit about our agenda today. We're going to begin with Ashleigh and Francesca diving into those upcoming compliance changes. Then we'll save some time for Q&A at the end. If you have questions throughout the presentation, please utilize the Q&A chat feature. We'll do our best to answer as many questions as we can live, but knowing that we have a pretty big group with us here today, we'll be sure to follow up with anyone whose questions we don't get to in their allotted time. All right, so without further ado, I'd like to introduce myself. I am Lisa Brown, Vice President of Client Services here at HR Collaborative. I've been in the HR profession for over 15 years now, working in manufacturing, retail, and consulting for the last 10. I've held almost every position here at HR Collaborative and in the HR field. And some of my areas of focus and specialty are total rewards, employee engagement, and people analytics. Over at Varnum, we have Ashleigh Draft, who's a labor and employment attorney. Ashleigh's an attorney on Varnum's labor and employment practice team. She's experienced in workplace investigations, defending clients in labor arbitrations, and successful resolution of employment-related disputes. She also advises clients on compliance with federal and state labor and employment laws and other workplace matters, including effective employee handbooks and policies, discrimination, disability accommodation, and wage and hour issues. In 2024, Ashleigh was named among labor and employment law best lawyers in America, ones to watch. Ashleigh has earned her law degree from Michigan State University College of Law, go green, go white, and a master's degree from Northern Illinois University and a bachelor's degree from Calvin College. Thank you for joining us, Ashleigh.
Thanks so much, Lisa.
Alongside Ashleigh is Francesca Parnham. She's an attorney at Varnum as well. Francesca is an attorney that supports Varnum's litigation and labor and employment practice teams. She's a skilled researcher with experience in a wide variety of labor and employment litigation matters, including before the National Labor Relations Board. It's tricky, Francesca. She earned her law degree from Michigan State University College of Law as well, go green, go white, and her undergrad degree from University of Vermont. Thanks for joining us, Francesca.
Thanks, Lisa.
All right, well, without further ado, let's dive in.
Sounds good. Thank you so much for that introduction, Lisa. I know that these topics have been incredibly stressful for so many employers in recent months as we prepare for changes coming up in 2025. So we are going to start our conversation today by talking about the Earned Sick Time Act, or ESTA. We'll talk about changes to minimum wage. And then finally, we're going to conclude by discussing some changes to the overtime pay threshold for salaried, exempt, and non-exempt employees under the Fair Labor Standards Act. So we're just going to dive right in. I think a lot of people are wondering, how did we get here with regard to ESTA, right? Michigan has had a paid sick leave law since 2018. Now, all of a sudden, after a Supreme Court decision, we know there are going to be changes to that law. So let me give you a little bit of background about how we got where we are. So Michigan's Constitution allows citizens to initiate laws by a ballot initiative. And that's what happened in 2018. There were two ballot initiatives. There was the Earned Sick Time Act, and then there was one called the Improved Workforce Opportunity Wage Act, which I'm just going to refer to as the Improved Workforce Act because it's kind of a mouthful. Now, Michigan's legislature, before there was an opportunity to vote on those proposals, Michigan's legislature adopted both proposals, and then immediately amended them. And there is no provision in the Michigan Constitution stating whether or not an immediate amendment is permitted after this kind of adoption. Now, I know that's kind of complicated, but the bottom line is that the Michigan legislature's actions in 2018 came under fire through litigation. And this litigation started in 2021, made it all the way up to the Michigan Supreme Court. And this summer, the Michigan Supreme Court held that the legislature's actions back in 2018 were unlawful. And so it ordered reinstatement of the laws in their initial ballot proposal wording. So our Paid Medical Leave Act that we've been living with since 2018 is now going back to the initial ballot proposal language in the Earned Sick Time Act. So, like I just said, this lawsuit was initiated in 2021. We just got a decision from the Michigan Supreme Court this summer in July of 2024. So, there are some key changes that many of you have probably already heard about between our Paid Medical Leave Act, which you'll see on the screen as PMLA, and the Earned Sick Time Act, which you'll see on the screen as ESTA. So PMLA, again, is what we've been living with since 2018. ESTA is the original ballot proposal language, which will be reinstated in February of 2025, unless there is legislative action to change it. And we'll talk about that a little bit more in a moment, because there is a possibility that there could be changes to ESTA before it takes effect in February. Okay, so Paid Medical Leave Act. It only covers Michigan employers with 50 or more employees. ESTA covers all Michigan employers, except federal government employees. So we have a much broader scope of who is being covered. In addition, the scope is broadened because PMLA only covered non-exempt employees in Michigan working 25 hours per week or more. Okay, ESTA, again, more broad, it covers all employees working in Michigan without regard to whether or not they're exempt, non-exempt, whether or not they're seasonal, whether they're full-time, part-time. As under ESTA, it does not matter. All employees of Michigan employers will be covered. Another unique thing about ESTA is that the definition of employee is a little bit strange. So under PMLA, we're used to having a really clear definition of who's an employee, right? It's whether or not the worker is on the employer's payroll. Are they a W-2 employee? Under ESTA, the language is different. We don't have that same clarity. Under ESTA, employee is defined by someone who is in service to the employer in the business of employer. Obviously, that's a little bit more vague. The thinking is that initially, ESTA, this was written to try and capture some people who would have been classified as independent contractors. Now, Michigan's Department of Labor and Economic Opportunity, that is interpreting and enforcing this new law, they have said that independent contractors, true independent contractors, are not going to be covered by ESTA. So we know that from guidance we've already received from that state agency, but that's probably the reason why the original ballot proposal was drafted with this kind of strange language, because they were trying to capture some independent contractors. Okay, under PMLA, employers have to allow people to accrue or grant up to 40 hours of earned sick time in a year, Under ESTA, that goes up to 72 hours. And the accrual is uncapped. We'll talk about that a little bit more in a moment. The accrual rate is also different. You can see on the screen there, under PMLA, we're used to 1 hour for every 35 hours worked, capped at 1 hour per week. Under ESTA, it's 1 hour for every 30 hours worked, and there is no cap per week. Again, under PMLA, employees were only allowed to carry over up to 40 unused hours. Under ESTA, you have to allow the employee to carry over all hours that they earn and accrue from 1 year to the next, and there's no cap. This is really unusual, and I know this is something that has been giving a lot of employers heartburn, right? Because you can cap employees' use. You can cap their use at 72 hours per year, but you can't cap their accrual and you can't cap their carryover. So what is likely to happen is we're going to have some employees who accrue large amounts of earned sick time leave, but they're capped at their use, 72 hours per year, and then we don't have to pay it out upon termination of employment. So it's going to really generate, I think, an unusual situation where employees may have these large balances of earned sick time that aren't very much used to them. A note about small businesses. So there is a provision under ESTA for small businesses with fewer than 10 employees. They can provide 40 hours of paid leave instead of the 72, but they must allow an additional 32 hours of unpaid leave. So just a note about how you classify someone as a small business under ESTA. Well, you have to have fewer than 10 individuals working for compensation in a week. You have to include workers who are engaged as contractors or through a staffing agency. It doesn't matter if the worker is full-time, part-time, temporary. And you lose this small business exemption if you have 10 or more employees for at least 20 weeks in either the current year or the preceding calendar year. And those 20 work weeks don't have to be consecutive. So as soon as a business meets that 10 or more employee threshold for 20 work weeks that can be consecutive or non-consecutive, then they are covered as a full-size business, not a small business, under ESTA for the remainder of that year and for the following calendar year. Okay, a few more key changes under ESTA. Under no-fault attendance policies, you have to exclude an ESTA absence. So some employers have no-fault attendance, doesn't matter if the leave is excused or unexcused, you get an attendance point. You cannot assign those points for leave taken under ESTA. Some changes to the notice provision that an employee needs to provide to the employer. If the need for sick leave is foreseeable, then you can require 7 days notice. If the need for leave is unforeseeable, then you can only require the notice as soon as is practical. Medical documentation, there's another change here. So medical documentation, we can only require it after 3 consecutive days of leave. And the employer has to pay for any costs that are associated with the medical documentation. So for instance, if the employee has to go to an urgent care to get the documentation, then the employer will have to pay that cost. And under any circumstances, you cannot delay giving someone the leave while you're waiting to receive the documentation. Okay, so other key changes that we see with ESTA. First of all, accrued and unused ESTA time has to be preserved if the employee separates, but then returns within 6 months. Has to be preserved if a business is assumed by a successor entity. So if a business is sold, all of the ESTA leave needs to stay with the employee at the new business. And then finally, if the employee transfers to a separate entity or a separate division within the same family of companies, the leave needs to stay with them. You need to keep records of ESTA leave for 3 years. So one of the really difficult things about this ESTA ballot proposal language is there are some presumptions against the employer. So if there is a question, let's say 2 years from now, whether or not an employer complied with ESTA, if the employer doesn't have any records that it's kept about its compliance, there will be a presumption against the employer. The agency, and if it's in front of the court must presume that the employer violated the act. So very important to keep your records and keep them for at least 3 years. Some posting requirements. I have a screenshot here of the Department of Labor and Economic Opportunities notice posting that they just came out with very recently. This is the English version. They're also creating one in Spanish, and I understand that they're considering creating some in other languages as well. If LEO, the Department of Labor and Economic Opportunity, has translated this poster into a language that's spoken by at least 10% of your workforce, then you need to put this poster up in that language as well. Okay, some additional difficult provisions for employers in ESTA. There is an anti-retaliation provision. Obviously, we can never retaliate against an employee for exercising rights under a statute. But interestingly here, there is a rebuttable presumption of a violation if an employer takes an adverse action against an employee within 90 days of the employee engaging in opposition type activity. Now, let me break that down a minute because I know there have been a lot of questions about this. This does not mean that you cannot discipline an employee for 90 days after they take paid leave. Like, that's not true. But what we do need to do is if we are disciplining an employee within 90 days of when the employee took action to maybe challenge the employer's practices under the act. So opposition type activity. Let's say an employee files a complaint with HR that they weren't given their leave properly. Maybe they file a charge with the state agency that will be administering this kind of enforcement. Or maybe they engage a lawyer or say they're going to engage a lawyer to enforce their rights. If that happens within 90 days, we have to be very careful about disciplining employees. It doesn't mean that it can't happen, but it means that we need to be taking a very close look to ensure that we have everything documented. We know what the rule violation is. We know that we've treated other employees similarly. So there is also a private right of action under ESTA. This means that an employee can choose to go straight to court, or they may file a claim with the state agency. And either of those can be filed within 3 years of violation. Employees can get damages, liquidated damages, reinstatement, and their attorney's fees, in addition to civil penalties. So as you can see, there are some questions still about who counts as an employee. Under ESTA, the employee can take leave for care for a family member or for care for someone who's closely associated to the employee in a family-like relationship. I know, very vague. So what are the limits of that? What are the limits of that close association? We are waiting for guidance from Leo to help clarify these things. Leo already has a FAQ website that it is maintaining and adding additional answers. So we'll continue to monitor that so that we know exactly how this will be enforced. Questions about ESTA and treatment of PMLA time. So in this transition, how will accrued PMLA time be treated under ESTA? We don't have guidance on that yet, but again, we expect further guidance on all these topics in the coming months. So compliance preparation, the effective date is February 21, 2025. So as of right now, employers must develop compliant policies and begin full compliance by that date. Now, could things change again? Maybe. There is no appeal from the Michigan Supreme Court decision. So the litigation path, the court path is closed. However, there may be further legislative action that would change some of the rules that I just discussed. And there, as I said, may be additional guidance and regulations from Leo that would interpret this law. I have a picture here. This is a leave behind document. So a flyer, basically, that a coalition of 55 business groups have been leaving behind with state representatives and state senators to try and communicate to them the really serious nature of a lot of these changes for Michigan employers. Okay, at this point, I'm going to turn it over to Francesca, who is going to talk about the Improved Workforce Act and changes to minimum wage law.
Yeah. Thank you, Ashleigh. Yeah, I will tell you that our Q&A is lighting up with lots of questions. So your short list of questions is not matched with the long list of questions we're getting here. Thank you, everyone, for your interaction. We'll get to as many of those as we can at the end of the presentation.
Yes. Okay, great. Thanks, Lisa. So I'll just be covering briefly the changes in the Improved Workforce Act, we're calling it. So the court's July 31st, 2024 opinion deeply affected the wage laws here in Michigan. So what will the Improved Workforce Act do? Well, first, we'll see an increase to the state's minimum wage. And this increase will be annual. So we'll see annual changes to the minimum wage based on inflation, which will be a rate set by the Michigan Department of Treasury. Lastly, it will phase out the current tip credit provisions. So this phase out will be over a 4-year period. And what a tip credit is, it currently allows employers of employees who customarily receive tips to count a portion of those tips in calculating whether the employees have been paid minimum wage. So these provisions will be phased out over the next 4-year period pursuant to the court's order. So what the court did and what's evident in the opinion is that, the court was very intentional about considering the burden that these changes would have on employers. So they did a bit of a balancing act. So they balanced the interest in restoring the act and the intent and account for the passage of time. Because again, these have been, the act has been in effect for about 6 years. So the court ordered a modified schedule. And we'll go through this a little bit more in depth in the next couple of slides, but just on a high level. As of February 21st, 2025, the general minimum wage will be $10 plus an inflation adjustment, which will be announced approximately November 1st of 2024 this year. And it's anticipated to be about $12.50 overall. So the general minimum wage will be about $12.50 as of February 21st, 2025. And then we'll see again those annual adjustments for inflation in those coming years. And then for the tipped workers minimum wage, as of February 21st, it will be 48% of the state minimum wage. So of that, approximately $12.50. Again, with scheduled increases each year thereafter, with the full phase out complete of those tip credit provisions in 4 years. Okay, so for the scheduled minimum wage increases, currently Michigan's minimum wage is $10.33 per hour. That's been since January 1st of 2024. And previously, prior to this decision, the state was on track to have the scheduled increases achieve $12.05 by 2030 as Michigan's minimum wage. So now, as a result of this order, a new wage scale is anticipated from the Michigan Department of Treasury, again, by November 1st, 2024. Every November thereafter, the state treasurer will increase the minimum wage based on the rate of inflation. And the act requires that the adjusted minimum wage rate be published by November 1st of the year and calculated so that it's effective that following January of the succeeding year. So every October, the state treasurer will calculate an adjusted minimum wage rate and publish that by November 1st, so employers have notice of that. So here is just simply an illustration of what this could look like. So the scheduled minimum wage increases, these numbers are just approximate again, and are yet to be determined by the Michigan Department of Treasury as of November 1st. But here we can see that on February 21st, 2025, we're at approximately $12.48, with the tip credit being $6.49. The minimum cash wage, you can see 48% of the minimum wage would equal $5.99. So then thereafter, all the way up to 2028, where we see a $14.97 minimum wage, and eventually you see that tip credit going down with the 4-year phase out. So again, this is just an illustration to kind of show you how this could look as of starting February 21st, 2025. And so then moving on to the tip credits, the other big thing that the Improved Workforce Act is going to change. So these provisions have, again, been in effect since 2019, so about 5 years. And the tipped minimum wage is currently set at 38% of the state's minimum wage. In 2024, so right now, that's $3.93. But as you can see on the chart on the right, the tipped minimum wage will go from 48% of the new minimum wage on February 21st, 2025, all the way down to, again, that approximate 4-year phase out. So again, a tip credit kind of forecast, we're calling it. This is illustrative of what this could look like. Again, it's subject to change, and we'll have more guidance on November 1st of 2024 when the Department of Treasury issues this number. So as of February 21st, 2025, again, the tip credit will be $6.49. That's approximate. And you can see how that number will reduce significantly over the next 4 years as those provisions are phased out. So as far as the training wage, this applies to employees that are younger employees and really anybody. A training wage of $4.25 per hour may be made to employees 16 to 19 years of age. So just in that span, for the first 90 calendar days of employment. So there's been no change to the training wage provision of the Act. And so, operating as usual as of February 21, 2025 for the training wage. Okay, so the potential implications of this. So this is going to have a ripple effect on other wage rates and really an overall economic impact. Specifically with restaurant employers. There was just recently a protest happening in Lansing. Lots of restaurants and the Association of Restaurants and Bars in Michigan are being very active about the topic, specifically regarding the 4-year phase out of the tip credit. So this is a photo. An estimated 600 servers and bartenders rallied in Lansing, again, just a couple of weeks ago, to preserve the tipped minimum wage scale that's, again, scheduled to be phased out in the next 4 years. Regarding compliance preparation, So again, employers must prepare for the new wage rates as of February 21, 2025. Could this change? Yes, as Ashleigh talked about, legislators have already proposed legislation changing this. The governor could also step in, to have some changes between now and February of 2025. So as of now, we're advising our clients to start preparing now. So we're ready for February 21. That's just a couple of months, just to provide some, ease and some mindset to get prepared for February of 2025. Could things change again? Like we just talked about, there's no appeal from the Supreme Court, but again, the governor, the legislators in Michigan are being active about this with proposed legislation. So we are encouraging folks to remain alert for those changes before February 2025. And if there are significant changes, look for Varnum to be putting out an advisory. We'll certainly have that on our website if there are any significant changes between now and February. Okay, I'm going to hand it back over to Ashleigh to talk about the Fair Labor Standards Act and the increased overtime threshold there.
Great, thank you, Francesca. So I know we have so many questions coming in through our Q&A function here. So I am going to move pretty quickly through the FLSA overtime threshold topic so that we have as much time as possible for Q&A, because I know there are a lot of questions out there. Essentially, we are now moving from talking about state laws to talking about the federal law. So when we talk about the Fair Labor Standards Act, that is a federal law that is administered by a federal agency, the Department of Labor. So under the FLSA, an employee may either be classified as exempt or non-exempt. I'm sure many of you are already familiar with this concept. An exempt employee is exempt from minimum wage and overtime pay requirements. Now, employers have the burden of demonstrating that a particular exemption is appropriate. And just choosing to label an employee as exempt is not enough. Even if the employee agrees, it's not enough. So it's important to go through the analysis and make sure that your people are properly classified under this federal law as either exempt or non-exempt. Okay, so how do we get to FLSA exemption? What's our path? Well, there are two prongs that need to be satisfied. There is the salary basis test and the duties test. Both of these tests must be met for an employee to be properly classified as exempt. Now, the change that we have seen both in July of 2024 and looking ahead to January of 2025, the change occurs with regard to the area that I've highlighted on this slide. So under the salary basis test, there are two pieces. One, the employee must be paid on a salary basis, paid the same amount every week, no matter how many hours they work, no matter what the quality of their work is. And then there is a dollar amount threshold that needs to be met. And it is that dollar amount threshold that has been changing and is scheduled to change again in January. So as of right now, in order to be FLSA exempt, in addition to the duties test, in addition to being paid on a salary basis, your rate of pay must be at least $844 per week. Okay, as I just said, under the salary basis test, you have to be paid in a salaried way, and you have to be paid a certain rate. There's also a duties test. I am not going to spend very much time on this right now, but as Lisa said, you will have a chance to look over these slides after the presentation, and I would invite anyone to come follow up with us. We'd be happy to help you do this analysis with your workforce. But there are essentially three different ways that an employee may satisfy the duties test. There are also specialized exemptions for computer professionals, outside sales, and highly compensated employees. So highly compensated employees under the FLSA have always had a slightly different test for exemption. And that test is in part based on the amount of money they make. So under the highly compensated employee test, that number has changed as well. Okay, so let's take a step back for a moment. Why is the Department of Labor doing this to us? Well, the Biden administration really has been trying to put more pay into workers' pockets, in part because federal efforts to raise the federal minimum wage have stalled. So this is sort of like a workaround that the administration through the Department of Labor has been pursuing. In fact, the Department of Labor in its press release anticipates that this new threshold will extend overtime protections to 3.6 million salaried workers around the country. So let's look for a minute about where we've been with this salary threshold level. In 2004, we were at $455 per week. 2016, many of you remember probably that there was an effort to change that level. That effort was rescinded. In 2019, there was an increase. And then here you see where we are now. As of July 1, 2024, we are at $844 per week, with the highly compensated employee threshold at $132,964. So where are we going in January? We are increasing again to $1,128 per week, or $58,656 per year, with another similar increase to the highly compensated employee threshold. Now, importantly, the new Department of Labor rule states that there will be automatic updates to this number every 3 years. So we would no longer have these long stretches that you saw in the past from 2004 to 2019, where there was no change to this threshold amount. So I'm just going to take a moment and say, where did these new numbers come from? Well, the Department of Labor is attaching these salary thresholds to the 35th percentile of weekly earnings for salaried workers in the lowest wage census region. So the Department of Labor did not just kind of come up with these out of thin air. They are tying it to a certain census region. Right now it's the South that has the lowest wages. Okay, so quickly, how to prepare for this? Well, first you want to identify all positions that are currently classified as FLSA exempt. Want to determine whether or not your folks are properly classified under the current standards. Determine whether or not they will remain properly classified under the new standards when the increase takes effect January 1. So for exempt employees who are earning less than $1,128 per week, they'll have two options. You can increase their salary and keep them exempt, or you can reclassify them as non-exempt and then track their hours and pay overtime for all hours over 40 in a work week. A lot of employers are considering ways to manage or limit overtime. You have to pay overtime for all hours worked over 40 in a given work week, but you can tell employees you're not allowed to work overtime unless you have prior authorization. And we'll pay you time and a half for overtime, but we may also discipline you if you violate this policy and work a significant amount of overtime without receiving prior authorization. So a few different approaches that employers are taking here. And that's all I have on the FLSA overtime exemption. I know we have so many questions, so Lisa, I'm going to turn it back over to you and let you walk us through some of the Q&A we have.
Yes, thank you so much, Ashleigh and Francesca. There are lots of questions. I know we're not going to be able to get through all of them. I will start with a few that came in regarding ESTA.
Yeah.
A lot of folks are curious, how does ESTA work in conjunction or concurrent with FMLA, short-term disability, other paid leaves?
Sure, absolutely. So let me just start by saying that FLSA leave and ESTA leave may run concurrently. So if an employee is taking FMLA, their reason for leave is FMLA qualifying, also qualifying under ESTA, you can have those leaves run concurrently, even though ESTA will be paid and FMLA may be unpaid, depending on your particular policy at your workplace. So those can always run concurrently. In terms of, how these leaves interact, it really is going to depend a little bit on your own policies in the workplace. Lisa, remind me, what was the second part of that question?
I'm sorry, what was the
second part of that question?
Oh, short-term disability, which, with a lot of plans is paid at some percentage.
Right, yeah. So you may use existing paid leave plans in general to satisfy the requirements of ESTA, as long as the paid leave plan is at least as generous as ESTA. Short-term disability probably will not meet those criteria, right? But you typically, I think most employers are going to be triggering short-term disability after ESTA leave has expired. So I also have seen, honestly, a lot of employers who used to have just one big bucket of PTO. They're all thinking, maybe we need to break off ESTA because the rules are so different. It allows this unlimited carryover, this unlimited accrual, and they don't want to apply that to their entire PTO bucket. So a lot of employers are thinking about breaking those off and tracking them separately.
That was a great segue into another question was particular to what to do if we offer, really that bucket concept, right? Like if we offer at least the 72 hours or our current plan is more robust than that, does that comply with ESTA requirements? So
right, and that's a great question. And it might comply with ESTA if you are offering that paid leave, that bucket of PTO, if you are offering it in ways that are at least as generous as ESTA. That means you are offering an unlimited accrual, okay, at least 1 hour per 30 hours worked. It means you are allowing that paid leave to carry over every year. Without any restriction, you are allowing the paid leave for any of the reasons listed under ESTA. Usually that is pretty broad with the PTO policy. You're not asking for documentation unless the leave has continued for at least 3 days. So all the things I was talking about under ESTA, if you want to use your bucket of general paid leave to satisfy ESTA requirements, you have to make sure that the ESTA rules apply to your entire bucket of paid leave. And that's why we're seeing some employers really think about moving away from a general PTO and tracking ESTA separately, simply because a lot of these rules just are so difficult for employers.
Yeah, I think that is definitely the challenge. Just a general question, which I would attempt to answer because I think I know, but I'm definitely going to leave this under the experts. When you talk about the accrual of 1 hour for every 30 hours worked, there's no cap. So if I worked 40 hours in a work week, that's 1.33 hours of, okay.
Yes.
That was one clarifying question.
Yes, yeah, absolutely. No, that's absolutely right. Another difference that I didn't mention in my initial slides that I want to highlight for people is the increments of time that you can use for ESTA leave. So there may have been some questions about that. I know there are a lot of people who are a little confused about this. Right now, you can tell someone you have to use your PMLA time in 1 hour increments, no smaller than that. Under ESTA, you need to let your employees use ESTA leave in an amount of time equal to the smallest unit you use to track time. So for instance, in the manufacturing environment, if you're tracking people's time in the 10th of an hour, you need to allow them to use ESTA leave down to the 10th of an hour. That is another thing that a lot of employers are really having a hard time wrapping their heads around. A lot of employers are hoping the legislature might change before February. And another reason why some employers, I think, are considering moving away from one big bucket of PTO.
Yeah, great. All right, we also have some questions on the, what is it? The IWOWA. I can never remember that,
Yes.
so I'm just going to go out on a limb, and it is a mouthful. One of the questions we got, Francesca, was, is there going to be a cap on the hourly minimum wage? We see the increase year over year through 2028. Are we anticipating there to be a cap at some point, or until legislation changes, is it going to continue to increase?
Yeah, I think the answer to that question is currently there is no cap, and it's set based on the Michigan Department of Treasury's inflation rate. So basically, what we've done is we've forecasted, and what other folks have done is forecasted out until 2028, even sometimes 2030. But beyond that, we would need to look to legislation. And that could change depending on who's in office and the status of the general election in November. So I think as of now, there's no cap. I think it's safe to say that the forecast is fairly accurate for the next 4 years or so. But beyond that, we'll have to just wait on legislation.
Yeah. And we've had a few people ask the question, like, how much of this are we anticipating actually going to impact or going into effect in the new year if the administration changes? And I know you don't have a crystal ball, so I'm not putting you on the spot, but is there a likelihood that, do you anticipate there changes if the administration changes to Republican from Democrat?
Well, so 2 things I will say. I would be a fool if I tried to predict what the legislature is going to do, because, it really, anything can happen, right? But the second thing I will say is I have spoken with legislators on both sides of the aisle, and I will say that there is an interest in modifying some of the rules we've discussed from both parties. So I've been kind of surprised and encouraged to see that really it seems like a little bit of a unifying moment, that a lot of legislatures are seeing, wow, some of these rules appear to be really unworkable for employers in Michigan. So they are taking a look at what they can do legislatively. But again, no promises.
Yeah, and I think one thing I'll add is that the time frame, with the November election, with the February 21st, 2025 compliance date, I think the time frame is a little bit quick. So we are advising our clients to, start your compliance efforts now, so you do have that ready. Of course, we can't predict what happens in November, but that timeline would be a quick turnaround for legislation to actually take effect. It's not impossible, but it's just all the more reason to, start your compliance efforts now.
Yeah.
I think that's, I think everybody's prepared, and the new administration wouldn't take office till mid-January anyway, right? So January 1st is going to come before then. Great. I think we have time for one more question. It's really hard to pick because there's so many questions. So of course, we're going to follow up with each one of you if we didn't answer your question live. I think that one that I'm kind of interested in too, and this goes back to ESTA and Michigan, because we know this applies to employees in Michigan. What about if the organization is based in Michigan and they have employees outside of the state, they don't have to comply with giving them the earned sick time. But what about folks who maybe work in Michigan, move or transfer to a position outside of Michigan, and then come back? Does that reset, or are there any guidance yet provided on how to handle those types of situations?
So that's a great question. We don't have guidance yet on that exact situation. What we know is that if an employee is eligible for ESTA leave, has a bank of accrued ESTA leave, switches to another entity within the same family of companies, that ESTA leave should be going with them. Now, if they are also moving out of state in connection with that transfer, it's a gray area whether or not they, that ESTA leave should translate into something else based on leave laws in their new home state, whether or not it should stay with them. We simply haven't seen any guidance on that yet from Leo. I'm hoping that we will, because it's these kinds of logistics issues that I think are going to be really tricky for employers and moving forward.
And what I'll add is that if an employer is located in Michigan, even if they're remote and their employer, or an employee, sorry, and if their employer is located outside of Michigan, they are covered under the Act, that employee. So even if the employer is located outside of Michigan, the employee is still covered.
Yeah.
And then beyond that, this also affects employers in determining the count and if they meet that threshold and whether or not they should be counting in-state and out-of-state employees. And again, we are waiting on guidance from Leo to kind of interpret the Act and shed some light on how to move forward.
Well, we have a ton of additional questions. So for those of you that we didn't get to answer in real time, apologies, but we will be following up. So as we are all, rushing off to our lunch hour and other things we have going on today, just want to leave you with a few things. So first and foremost, thank you so much to Ashleigh and Francesca for being our subject matter experts here today. If you'd like to connect with them to discuss how these legal changes will affect your workplace, you can get in contact with the attorneys at Varnum. Phone number and email addresses for both Ashleigh and Francesca are up on the screen. We'll also include in our follow-up email with the slides. Just a heads up, if you haven't had enough webinars or you're looking to really absorb all the information you can this month, HR Collaborative will be presenting next week on another webinar in partnership with the Detroit Regional Partnership and part of their Expert Insights series. We're going to be speaking with one of their team members on total rewards and how building a compensation strategy can help you attract talent in Michigan. That is next week, October 10th at 11 a.m. It is another Zoom webinar, so you can log in and listen along. Of course, if you haven't already, you can skip the social feed with our curated reads. So our topics are handpicked to keep you up to date with the current changing landscape. So pop out your camera or click subscribe to our newsletter when you receive our follow-up email. So with that, a big thank you to all of you who came and spent a part of your day with us. We know that there's a lot of changes, a lot of things that are impacting you and your business, and we're delighted to be part of the conversation. And one last big thank you to our panelists, Ashleigh and Francesca, for being subject matter experts and providing the insights from your team at Varnum to share with all of our participants here today.